I'm calling the meeting to order of the Zoning Board of Appeals on this date at 4:10 p.m. Say something.
Okay, so is there anybody on the call who's having any technical problems before we get started? It seems like everybody's present. All right, so the first item on the agenda is an update on developer application to Mass Housing for a 40B project eligibility site approval letter. And so I'm going to keep this real brief just to summarize the key points that have been provided to the board and others by email, which is that there is application pending with Mass Housing for a project eligibility site approval letter, which is a necessary first step before an applicant is eligible to apply for a comprehensive permit locally under Chapter 40B. So there's normally a 30-day comment period for town comments, but Mass Housing did grant the town's request for an extended comment period to account for the inefficiencies associated with the inability to meet formally in person. So the town has until Tuesday, June 16th to provide comments to Mass Housing. So my office and the Board of Selectmen put out a call to all town departments, boards, commissions, and committees, as well as the broader public, to provide any and all questions, comments, concerns that people have. We've been receiving a lot of correspondence coming in, both from town departments and boards and committees, as well as town residents. So that's all being provided to the selectmen, and I'll be working with the board over the next couple of weeks to pull together comments on the town's behalf to go to Mass Housing on or before the June 16th deadline. And that will include as attachments many, if not all, of the correspondences that we've received. So that process is well underway. The selectmen held a site walk this past Friday that was attended by a couple of members of staff, 2 members of the board, the applicant, Chip Hall, and I think that's it. And there have been updates on this process provided on a regular basis on the Board of Selectmen meeting agendas, and that's expected to continue through the site eligibility process. So I think everyone knows this, but there is no permit currently pending before the town of West Newbury. The Mass Housing process is a required initial step. So we're really at the stage of identifying issues that would need to be resolved or addressed in more detail if and when a project actually gets to the permitting stage. So that was impetus for this training, which is the next item on the agenda. So unless there's questions on that, I would turn it over to Phil DiMartino from DHCD, who has prepared a presentation.
Angus, I have a question, Bill Backrack. On the planning board memo that came for the planning board meeting notes, can you go through that as well? Or is that going to be part of that? Because I'd like to have that idea before we go into what the gentleman's going to talk to us today.
Are you referring to the draft comments that the planning board is going to be reviewing?
That's correct. Yep.
Pretty extensive, as I recall. That I think it would take, depending on how much time we have to comment on the planning board's memo, draft memo, might be cumbersome. I'm not certain.
I think we should focus on the training that's at hand that Bill's here to provide, and then we could talk about that later.
Yeah, I'm just trying to understand though, before the training, is there something in that planning memo that they talked about that's going to have an effect on this training, and trying to understand? That's all I'm trying to understand. Is there a correlation at all?
The training is not specific to the proposed project, and Phil doesn't have any awareness of that. So the training is a general training on the 40B statute and regulations geared toward the Board of Appeals and your role as the regulating entity for that.
All right, thank you.
So when we, as we get to the end of the meeting, there will be the board will be asked to set a date for one or more future meetings, and that might be an opportunity to go into more detail on that proposal.
All right, thank you.
So Phil, you want to get started?
Right. Are you going to pull up the PowerPoint or should I do that?
Yeah.
Or
Yeah, no, I've got that. So I just,
Okay. Great. Okay. Thanks.
hold on, it's on the
Sure,
wrong
All right.
slide too. There we go. Okay, does that come through clearly for everybody?
Yep.
Works for me. Okay. Thanks for setting this up. So this is just the cover slide. So we'll go to the first slide with some information on it. Just a background on 40B and housing production. If you look at this chart closely, you can see we're producing about half as much housing as we did in the 1960s. So we have an extreme housing shortage in the state. The interesting thing is the most recent data is we're producing almost as much multifamily housing now as single family housing. So, but again, a real shortage of housing production overall. And that's part of the reason we're seeing 40B used all over the states. Traditionally, you know, it was with 128 belts, sometimes 495, but we're seeing 40B used out in Western Mass, Cape Cod, pretty much everywhere now. So next slide. So what is 40B? It's a state statute. It's almost, well, it's 51 years old now. It allows developers to override local zoning in towns with 10% or less affordable housing stock. And I'll get into what constitutes affordable. It's a pretty strict definition. It's produced over 65,000 units and over 1,300 developments. And truthfully, these numbers are a little bit older. It's probably closer to 70,000, probably closer to 1,400. It's the most powerful zoning tool we have in the state by far. It's much, much bigger than inclusionary zoning, anything produced via CPA. It's a very powerful tool. As you probably know, it's also very controversial. Massachusetts is what's called a home rule state. So we've got 351 cities and towns, 351 set of zoning laws. There's no real comprehensive regional zoning in the state. One thing we were working on before COVID and everything sort of blew up was zoning reform, moving the 2/3 supermajority down to a simple majority. I'm not sure what's going on with that. I think if we had less easier, if zoning was easier to change, I think we'd probably have less 40B activity, but I think there's a lot of movement towards 40B for a variety of reasons, which I'll get into later. You may or may not know there was a ballot initiative back in 2010 to eliminate 40B, again, because it's controversial. That passed fairly easily, 58 to 42%, but as someone who's worked in 40B now for about 15 years, it's not an easy process for ZBAs. We try to help them as much as we can. There's a lot of misconception about 40B, so happy to answer questions when we get through it, but it's a work in progress for everyone. Next slide, Angus. So how do unit counts towards 10%? This is sort of the big picture because we always get a question, how do we come up with these numbers? Why are we at this percentage? How come this counts? How come that doesn't count? They must be part of a subsidized development built or operated by a public agency, nonprofit, or limited dividend organization. Frankly, most 40Bs are limited dividend organizations, groups formed just for one project. There are big national developers like Avalon who frankly aren't really in the affordable housing business. They really use it as a zoning tool to get rentals come on, in big numbers. If you drive up and down Route 128 and you see these big 200-300 units, they're almost exclusively 40Bs. So at least 25% of the units in the development must be income restricted to families with income of less than 80% of the median income and have rents and sale prices restricted to affordable levels. And I'll get into those numbers later. Because the area income in Massachusetts, particularly in Metro Boston, is so high, this really isn't, a low-income housing program. It's not Section 8. In order to afford, generally, particularly ownership, you've got to, still be bankable, be able to get a mortgage in the private market, and have a decent income. The restrictions must last for 30 years for ownership or 15 years for rentals. A few years ago, we developed something called the Universal Deed Rider, which basically any new construction usually coming up now is all for 99 years perpetuity. So we're not seeing these developments go market rate. It just doesn't happen. Some of the earlier 40Bs that had not great deed restrictions or regulatory agreements did go market rate, so that was a problem. I sort of jumped down to the next thing. So the development is subject to a regulatory agreement monitored by a public agency or nonprofit agency organization. So once these things are up and running, whether you're selling an affordable unit or you're marketing an affordable unit, there's a third party that makes sure that people are qualified. And there's income and asset restrictions for that. The owners must meet affirmative marketing requirements. So that, in other words, you can't just give these units out to anybody. The developer generally works on the affirmative marketing plan that must be submitted to the subsidizing agency, Mass Housing Partnership. I'll get into that. You can ask for up to 70% local preference. I'm not sure if you're doing that, through the public comment period. Generally, that's granted, so that helps sometimes, get the project a little bit more support if people think that the majority of the units are going to go to local folks. You can't exclusively say only folks from West Newbury, Newburyport are here. It's just, because there's public dollars involved in this. You have to meet fair marketing requirements. A few years ago, we started counting DDS and DMH group homes. So if you have a group home, a lot of times these are larger homes. Sometimes they're apartments, usually larger homes. You might have 5 residents or consumers from Department of Development Services or Department of Mental Health. Each person counts as an affordable unit. It's not actually a home, but we did this to help boost up the community's count. Now, for sale 40Bs, they're subject to a 20% profit limitation. That's usually done at the end of the process by the subsidizing agency to make sure that the profits aren't exceeded. For rentals, it's a 10%. It's not really per year. It's 10% of their total development costs and basis. They have to submit annually to the subsidizing agency to make sure they go along with that.
Pick it up and hang up.
Next slide, please.
The other hang up.
Right. So how does the process actually work? So I know you've got a project happening now. So upon receipt of the application, the subsidizing agency provides notice to the municipality, and they have to say at least where the project is located. They initiate an initial 30-day review and comment period. And just from speaking to Angus earlier, I wasn't sure if it was June 16th or June 17th. So you have time now to add some more comments. And I'd advise you, whatever issues you have, the comment period is, I won't say it's a free-for-all, but you can bring up a lot of issues there that aren't really under the jurisdiction of the ZBA. So that's your time to bring up the issues you have with the subsidizing agency. We encourage open communication between the municipalities and development team. And before the process can move forward, they have to do a site visit, which Angus just said, I think they did it a few days ago. So that's where you're at. Next slide. As Angus mentioned earlier, before you actually get to the ZBA, you need what's called the project eligibility letter. If a developer doesn't have an eligibility letter, they can't move forward with the 40B process. There's 4 agencies that can issue them in Massachusetts: Mass Housing Partnership, Mass Development, and my agency, the Department of Housing and Community Development. Frankly, I'd say 70 to 80% of the letters are issued by Mass Housing and Mass Housing Partnership. Mass Housing Partnership generally does exclusively rentals. They tend not to do a lot of elderly or age-restricted housing. DHCD, we issue eligibility letters for some of our programs, like the Low-Income Housing Tax Credit Program. Most of the 40B letters we issue are under what's called 40B. Friendly 40B. So in other words, the municipality's on board with it, and they want the project to happen. There are some situations where the town wants a 40B, it could be age-restricted housing, and that's what they do. So once the developer has a PEL, they can file a comp permit with the ZBA. That's you folks tonight. They also need evidence of site control. They don't necessarily have to own the property outright. They can have a purchase and sale agreement. Sometimes the P&S is contingent upon granting of the comprehensive permit, but they have to have something vested, before they get to the stage. So next slide. Now, because the 40B process has some very strict deadlines and it's sort of its own world, it's separate from any local zoning. Developers have to pay fairly hefty fees to apply for a project eligibility letter. Some of those fees are used to help the ZBAs navigate the process. So MHP runs a technical assistance program, grants up to $15,000 for qualified third-party consultants. And I've already sent this information up to Angus and Sam. So I know they're working with MHP. They can probably fill you in later. So hopefully they will get a consultant. And that consultant will sort of sit with the ZBA throughout the process, make sure that, things that are being addressed in a proper format. Sometimes there's things that the ZBA really shouldn't be looking at by case law. They'll actually help write the decision. So in other words, you won't be alone during this process. And because it can be overwhelming. I mean, some ZBAs have never dealt with a 40B. You might be used to just somebody wants to build a deck or, some minor issue. And this is, a big issue for the town. It's a big development. And usually when 40Bs come in, there's a lot of concern a lot of times. So next slide. So say, hypothetically that the PEL is issued, how does it work? Well, one good thing is at the top here, Chapter 53 of the Acts of 2020, this is because of COVID, you can delay the opening of the hearing till 40 days after the state emergency is lifted. And you can check with your town council as far as that's going to work operationally. So, but that will give you some more breathing space because I think we're all struggling with the situation. And, nobody wants to rush this process. So who knows when the state of emergency is being lifted, but, they have to get the PEL, they could apply, and then you could wait until 45 days after the governor lifts the order. So putting that aside, let's just say you have it, you're going to start the process. So within 7 days, you should distribute the application, and there wasn't really enough room to go in here, but you can send it to, Planning Board, Conservation Commission, Public Safety, really whomever you want. There are certain groups that need to get a copy of the application. Within 14 days of getting the application, you should post a notice of a public hearing, and that I think just follows under 48, which you would be doing otherwise. Now, within 30 days, you have to open up the public hearing. That's very important because if that deadline is missed, and it's happened, you can get what's called constructive approval, which whatever the developer comes in with. And frankly, under 40B, they usually come in with a much bigger project than they end up with. There's some sort of horse trading going on. You just want to make sure you open up the public hearing in a timely fashion because you don't want to be in that situation. After that, there's a 15-day notification period called the safe harbor notification period, and there are various safe harbors under 40B that I'll get into. The best, the one that's most known is the big 10%. If you're over 10%, you're essentially free from 40B. And there's things that we've added through regulations and things that are in statute, which I'll get to later. So if you did think you were at 10%, you could say, we're at 10%, you send that off, and I'm just giving you the quick version. The developer can challenge it. DHCD would issue a decision within 30 days. It's not really on this slide because there's a separate appeal process after that where they can go to the HAC, the Housing Appeals Committee, and do what's called an interlocutory appeal. And that decision is just based on the safe harbor, whether or not you're at 10%, you've achieved the general land area minimum, it's a related application, things of that order. But in general, you have 180 days to close the hearing, conduct everything. In reality, most of the 40Bs go well beyond 180 days. If you're working in good faith with the developer, things are moving ahead, it can go on, for a year, and that happens, as long as everyone's on board with it. The town would have, or the ZBA would have 40 days to issue the decision, and then there's a 20-day appeal period after the 40 days. Next slide, please.
Oh, who is, I'm sorry, when you say everyone is on board, can you define everyone, please?
Well, everyone would basically, if you want to extend the hearing, it'd be the ZBA and the applicant. So that would agree to it, and it should be in writing.
So
if
what
you're-
happens if the applicant doesn't agree?
If the applicant doesn't agree,
Yeah.
you should then issue a decision within 180 days.
Okay, all right,
Yeah.
thank you.
That's a good question. So, and that's every 40B hearing is a little bit different. Sometimes, and I'll get into this, my it's not my legal opinion, and I know communities have their own idea what they should or shouldn't do. You're better off sometimes if you can sort of get to a project you can live with at the ZBA level. And we'll get into the various appeal processes, but if you look at the Housing Appeals Committee and case law, the statute is very powerful. There's, it's communities have fought 40Bs. I know some towns have been fighting for over a decade. So it's a tough battle. So 40B, this is assuming, that they've got the project eligibility letter. What does the application really contain? So they should have preliminary plans, existing site conditions and locus maps, scaled architectural drawings, tabulations of building types by type, size, and ground coverage, a subdivision plan if applicable, a utility plan, and probably the most important one here is the list of required waivers. So they're going to need waivers. Could be from anything. If you have density requirements, if you're a community that only allows 2-acre zoning and they're doing rental development, they're going to need, relief from the zoning, a waiver from that, and that's generally it. If you're a community that has the stretch code and they don't want to do the stretch code, they would ask for a waiver from that. So it's whatever they need to ask to make the project happen, and that can be, sometimes these waivers are pages of things that they want relief from. Next page.
Phil, if I could,
Yeah.
I have a question on that. My understanding had been that the stretch code as the state building code was not waivable. Is that not correct?
Yeah, it's a good question. I've been told that it is waivable because I don't think they have to meet state building code requirements. Now, I know local municipalities adopt the stretch code. It's something you can negotiate with during the ZBA process, but I think they have to ask for a waiver. I can check with my legal counsel tomorrow and get back to you, but that's what I've been told. Because as the stretch code, it hasn't been adopted into the state building code, has it?
Yeah, it has its appendix AA, and it's just local option whether or not to
Right.
use it or not. But it is part of the building code itself.
Okay. I've been told that they would ask for a waiver from it, but I'll clarify with legal. It sounds like it's sort of grayish, but I know more communities are adopting it. Okay. So next slide, Angus. And as far as peer review, because when these things come in, traffic is always an issue. So the developer oftentimes will have traffic studies or engineering studies, and the community can get peer review to sort of look at what the applicant has prepared to see whether or not they're in agreement with it. All peer reviews, results, and reports are made part of the record, and I just cited the state law that allows for peer review payment, and generally the developer should be paying for it. Next slide.
Actually, I just had a request to go back to slide 8, so I'm going to just do that very briefly.
Yeah.
Dennis, did you have a question on that?
I just wanted to grab a screenshot of it so I can, I know we'll probably get a copy of this, but I want to keep these dates in the back of my head. So thank you.
Sure.
You can proceed. Thank you.
Okay. So we were, I believe.
I think we're just finishing this one up. So next one. Okay. So one thing to remember is there was, and I sent this out to Angus, and feel free if you want to circulate it. There was a kind of a landmark SJC case involving the town of Amesbury, who sued the Housing Appeals Committee about what they can and can't sort of go into as far as their purview. So this case really sort of set out what the ZBA should be looking at. So it addressed the question of what is the scope of the ZBA's authority under 40B. So it really is looking at health, safety, environmental, design, open space, and planning. Before this, we had ZBAs would sort of put conditions upon, some things like property management, trying to cap the number of children, things that were really outside the scope of the statute. So this is something that the consultant will help you with, but it may be worth looking at that SJC case just, to get up to speed. Frankly, a lot of the issues as far as, which are real issues. I'm not somebody who goes around and says 40B doesn't have impacts on communities, because it does. But things like school impact or overall financial, community character, which is just very, it's kind of a quagmire as far as to define. It doesn't hold a lot of weight if you end up at the Housing Appeals Committee, and it's not something really that the ZBA should be looking into, particularly the financial, whether or not the developer's profit limitation is going to come in at 15%. Sometimes ZBAs would really get into how much they were making. We've had other ZBAs kind of go after, well, not so much ZBAs, but community groups, the developer, something happened to a project 10 years ago, trying to bring that up. So it's just good to know, because you don't want to get yourself in trouble as far as what the ZBA should and shouldn't be looking at. Next slide, please. So say the process goes through and you've got down to the end of the process, and you've got really three options as a ZBA. You can deny the project outright. I wouldn't recommend that, because you're basically just guaranteeing an appeal to the Housing Appeals Committee. Approval as submitted virtually never happens unless you have, say, an elderly housing project with deep operating subsidies. Everybody loves it. I've seen a few of these. It doesn't happen that often. The third one is the most likely scenario: approval with conditions. So if a developer comes in and they want, 130 units, and you end up negotiating down to 85, but there's been a thoughtful process, people are on board with things, that's the most likely outcome. Now, if the developer, let's just hypothetically, if they're asking for 120 units and you end up saying, we'll give you 40, they're most likely going to appeal to the Housing Appeals Committee. And that's a group that's housed at DHCD. And that's essentially a trial. And they'll go through, it's called a de novo hearing from the beginning, and look at everything that happened. Most of the HAC cases revolve around whether or not a project is uneconomic or feasible. But the reality is, if you get to the HAC, if you're below 10%, you haven't met safe harbors, you deny a project, the HAC is viewed generally as being probably pretty favorable to developers. So that's why, and again, easier said than done. I know it's a tough situation. If you can negotiate something on the local level, you may be better to avoid the Housing Appeals Committee. Now, beyond the Housing Appeals Committee, and this is what happened in Amesbury, other parties can appeal to the Superior Court or Land Court, and these things get tied up for years. This is outside the jurisdiction of the ZBA. It's outside the HAC, and the developer can't really move forward unless they get a building permit. So we have seen some projects end up in court for years and years, but it's a calculated risk because it's expensive, because the towns generally have to, pay the legal fees for this. Unless some communities, I think, just do it because they have tons of money, and they might have a wealthy benefactor who doesn't want the project, and it can go on. And, again, I've seen 40Bs go through litigations for 10 years. Next slide, please. So I spoke about earlier that the 15-day hack interlocutory appeal, these are what's called safe harbors. These are things not in the statute, and the statute goes back to 1969. So these are things we've added through regulations since really we started doing these back in 2001. Recent progress, if they've reduced 2%, and I should have included what SHI means. SHI is subsidized housing inventory, and that's really the sort of technical name for the 40B list, because there's lots of things on the SHI that aren't 40B. For instance, if you had a housing authority, all housing authority projects are on there. You could have housing developed through inclusionary zoning, not 40B. They're on there, things that are developed through the CPA. So there's a lot of units that aren't 40B centric. And that's why most cities are over 40B, because they have a lot of housing authorities, a lot of units. Boston, Lawrence, Worcester, our big cities, 40B is not an issue because they exceed 10%. Mostly because they have a lot of units that are under the auspice of the housing authorities. Section 8, well, they're technically now called housing choice vouchers, where the voucher is tied to a person. So Phil can move from West Newbury to Salem to Weymouth. Those don't count. But if you have a project-based Section 8 that's tied to a physical address, they would count. So anyways, the recent progress, if you did 2% of units that count for the SHI, you'd have a 12-month sort of safe harbor. And for West Newbury, that's 32 units. This one was interesting because you're a pretty small town. So this one's called the large-scale project. So caps project size, depending on the size of the community, unless the ZBA chooses to go with a bigger project. So 40B is right now all based on the 2010 census. So you've got 1,558 year-round housing units. So the cap is 6% of total housing units for towns under 25,000. So for West Newbury, if my numbers are right, that's 93 units. So in other words, that might be something you want to bring up in the comment period. I don't think, unless the town wanted to, that you could get a 40B larger than 93 units for permitting. Now, they may come in and be asking for 140, 150. I don't know, other than what I've read in the paper, what this proposal is, but that's something to keep in mind of. The last one is called related application. So that enables a town to reject a 40B if a developer submitted an application for the same physical site without any affordable units. Now, if they said we're going to do 10% affordable units, that wouldn't be applicable. This was really put in to stop developers saying, you know, if you don't let me do my subdivision, or if you're not going to let me do, you know, my market rate development, I want a little zoning relief, I'm going to come back with a 40B next week. And that did happen. And frankly, it happens now to some degree, but at least they have to wait a year. So that gives you some breathing space. Next slide.
And sorry if I know this is a ZBA meeting and I'm not on the ZBA, but if a developer comes in at 60% above the safe harbor cap of 6% of our 1,558 units, it seems
Right.
like it's kind of put us with our backs up against the wall. We don't know that we can, if we don't take advantage of the safe harbor within the allowable 14 or 15 days, we don't know that we're going to come up with something that he doesn't then appeal, and we end up ultimately stuck with 152 units. So I'm just trying to understand strategically what makes sense for the town. We're not close to affordable housing, but
Yeah.
it seems like we're kind of are, again, put up with our backs against the wall by the number of units he's looking for.
And
Yeah, I know what you mean.
Phil, just so you know, that's Rick Parker speaking. He's a member of our Board of Selectmen.
Yeah, no, it's a good question, and it's funny because it's unusual to see a developer come in with numbers so in excess of what the safe harbor cap is there, 6%. But that doesn't mean, although I should qualify this, that's a very good question actually, because even though I have this in a sort of safe harbor related, slide, it's more to protect our smaller communities, because, and it sort of says, 2,500 unit is 6%, and then it goes up to, I think it's 5,000 units, 7,500. The biggest 40B you can do is 300, because he's coming in at this number. You really wouldn't be able to stop it at this point because you haven't permitted. So I know what you mean. It's a little, I think it's probably a strategy to come in with a really big number, because they must know, they know the regulations, and that you don't have to permit 150 or whatever he's coming in for. The most he's going to get, I think, is 93. But you, unfortunately, in this situation, have to go through the permitting process, because there hasn't been a lot of, as far as I know, 40B activity in the past.
So would that be so if safe harbor was declared and it was either agreed to or not agreed to by the court, what is the next step? Would it be a totally different submission 1 year later by
Right.
the developer?
No, it's a good question, and I'll jump to that. I'll give you the quick answer, and then a slide comes up and explains that. Unfortunately for safe harbor, the safe harbor has to be achieved at the time of application, and the units have to be eligible. So in this sense, even though it is technically a safe harbor, it's more of a protection against a very, very out of scale project. Now, you probably still think 93 units may be out of scale, and that's I think a reasonable argument, you know, from a town's perspective. But in order to use the safe harbor provision, those 150 units would have to count at the time of the application. So in other words, you'd almost have to permit it to protect yourself. And it probably might be clearer in a slide coming up. So in other words, he's just coming in with a project now. He's coming in with big numbers, probably knowing he's going to get you're going to have to negotiate way down. Unfortunately, the project, just because it's filed with the ZBA, it's not eligible for inclusion on the SHI. So you wouldn't be able to use the safe harbor provision under this scenario, you know. And even though it's referred to as a safe harbor, in this situation, it's probably more of a municipal, I don't know what I'd call it, more of a, you know, like a municipal cap. But I don't think he'd be able to claim safe harbor because he's coming in with a big number, because the units aren't eligible for the SHI. And I know it's confusing, but it might get a little bit clearer when I get to the next couple slides.
Okay, thank you.
Yeah, it's a tough one. It's unusual to see that those numbers that big, because usually they kind of come in around the cap, you know. So this is managing the comprehensive permit. The subsidizing agency, again, that's Mass Housing, Mass Housing Partnership, Mass Development. They're in charge of what's called final approval, which happens generally after construction, that everything is up and running. They oversee the drafting of the regulatory agreement, the deed rider for ownership units, the monitoring agreement. They have to approve the lottery, fair housing, and local preference. The subsidizing agency, more likely, sometimes DHCD, we do our own monitoring. Mass Housing Partnership contracts a lot of it out to third parties. They check the eligibility of owners and tenants, and to make sure that they're complying with the limited dividend restrictions and cost certification. So in other words, they also have to post, the developers have to post a surety bond with us to make sure that they're going to give us all this information. So they're not just, you know, building the project and selling it and running, you know, that we make sure that they're complying with the profit limitation. The town and the ZBA oversees final engineering, architectural plans, does the inspections during construction. Now, sometimes I think people think that they don't have to meet state building codes. They still do. They have to comply with all relevant state building codes and Wetlands Act, anything that's a state statute or regulation they have to comply with. They deal with lapses of permits, a transfer of the comp permit that would have to be approved, because sometimes these things do get sold. Changes to permit, substantial or insubstantial. Sometimes, I don't know what's gonna, you know, this situation is crazy, but when we had the last meltdown, we had a lot of 40Bs that were age-restricted housing, because communities like to do age-restricted housing because there's no school kids. A lot of them came back and asked to have the age restriction removed, and that could be a touchy subject. That would be a substantial change, so the ZBA would have to approve that. Next slide, please. Housing production plans. This is a program that started back in 2001, because a lot of communities we were hearing saying, you know, we're never going to get to 10%, but we need some help. So it's a voluntary program. If you submit a housing plan to us and you produce a certain amount of housing, and I'll get into your numbers in a minute, you've got 1 year for half of 1%, a 2-year moratorium for 1%. These numbers are probably a little outdated. Since 2003, we've had over 60 communities achieve certification, either for 1 or 2 years. We've had over 100 plans submitted, which is a pretty decent number, probably closer to 120 now. And there's no penalty for not achieving the goals. So a lot of times towns will say, you know, we don't want to do this, we're not going to achieve it. We don't go around saying your plan's not valid because you haven't done anything in 5 years, but it's a good thing to have. Right now under the Housing Choice Program, you get some bonus points, I think, if you have a certified housing plan. And if you do get a big development, at least you're going to get, you know, a 1 or possibly a 2-year moratorium from 40B. So if you go through this process and produce, you know, a lot of units, you're going to get a good amount of time off. Next slide, please. So there's 3 main requirements: a comprehensive needs assessment. affordable housing goals, and implementation strategy. So, and it needs to be approved by the planning board and board of selectmen and or city council and submitted by the chief executive officer. Next slide. Get my notes here. And in order to be certified, of course, you need to have an approved plan. You need to produce production of units in the same calendar year for which they're requested. This can get touchy because sometimes projects get delayed or permits get modified, so that's something to keep an eye on. It's pretty straightforward. You just write a quick letter saying we're requesting certification based on project X. We have 30 days to look at it. The certification is retroactive to the date of initial eligibility. But if you have a 40B that's already at the Housing Appeals Committee, and a lot of communities will do this, bigger communities, it's held harmless. So it's really going forward. It's not, you know, it's not for the 4 or 5. You might have some ZBAs. When I was dealing with Brookline a lot the last 2 years, they had 8 or 9 40Bs at one time in front of the ZBA. So it became, you know, who's on first, because it really, you know, if your 40B was filed before you hit safe harbor, they're grandfathered in. But if you hit safe harbor today and somebody comes up tomorrow with an application, you can deny them. So this gets tricky. So I always tell communities to check with us. Next slide, please. So the good news is West Newbury has a plan. There was a big regional thing with the Merrimack Valley Planning Commission we worked on. So it's good until June 17th of 2023. So if you produced 8 units, 1%, you'd get a year off. If you did 1%, sorry, that's 16, you get 2 years off. And the SHI, this again is the 40B number. So you're currently at 2.5%. We're updating the list now, so there might be some difference in that. So stay tuned. And I'm going to double check this. The 80% number, this is the maximum you can go under 40B is, this is Metro Boston. So it's probably fairly accurate. I just wanted to double check with HUD. So one person can make up to 62,000, 2 could be up 71,000, 3 person just over 80, and 4 person almost 90,000. So again, I think people see 40B and they say, oh, you know, it's going to drastically change. I mean, these numbers are, you know, decent incomes. So in order to, particularly under ownership, you have to be making it, you know, a decent amount of money. And every March, these numbers change. Now, the monitoring agents and subsidizing with the subsidizing agency will determine the rents and also the for sale process. You know, the rents have gone so crazy in Massachusetts. If you look at once the 40B application comes in a pro forma, they'll tell you sometimes what the market rents will be. And, you know, in the 128 belt, they're looking at $2,200 to $2,400 for a 1 bedroom. And the 40B affordable rents might be $1,700 or $1,800. So we're not talking low income housing. You know, a townhouse might be, which is where you make, you know, it's probably a better deal. A townhouse market rate in a 40B development theoretically could be anything. It could be, let's guess, 450 to 550,000. The deed restricted one might be 250,000. That's a difference. I mean, I'm seeing 40Bs now in Wellesley and Sherburne, where the market rate developments are for a townhouse are over $1 million, which is, it's kind of crazy because, you know, there's such a shortage of land, there's such a housing demand that we're seeing 40B go into, you know, Weston, Sherburne, Concord, Lincoln, Dover, the wealthiest communities in the state. Next slide.
So can you go back? I'm trying to understand something. So you said the certification of there's 0.5% is 8 units, 1% 16, and
Right.
SHI is 2.5. So that means we're at 2.5. So how does that affect us at all?
Well, right now, as far as this project, it wouldn't necessarily affect you at all. This is if you were to create 8 units or 16 units of housing that qualifies for 40B, for the SHI, the subsidized housing inventory, you'd get a 1 or 2 year moratorium. The issue is you have to have that sort of in place, that certification. And as far as I know, I'm not sure what's happened affordable housing wise, other than this pending project. It really wouldn't impact what's coming down the pike. This is something where if you end up permitting a project, say with 16 units next year, just put this other project aside, you'd get a 2 year safe harbor. we'd write you a letter saying West Newbury's, certified from May 20th, 2020 to May 19th, 2022. Somebody comes in with a new 40B, you'd say, we've achieved safe harbor during that 15-day process, and you could essentially deny the project.
And it has to be within that year, and so Angus,
Yeah.
do we have any 40B units that's been done in the past year or so? I'm just trying to understand where we're at.
We do have a handful of units that are eligible. They're not technically 40B units. They're under the local initiative program, which is the other way to get units added to your subsidized housing inventory. But the planning board does have an inclusionary zoning requirement. So 10% of units in the developments that have been built for the last few years have been qualified affordable. But we have not produced 8 or anything close to 8 within a single calendar year. So we're not currently certified under the housing production plan.
Great, thank you. That's what I wanted to clarify. Thank you.
That's a good question. Next slide, Angus. So I've talked about some of the other safe harbors or municipal relief that are more regulatory. So these are the 3 safe harbors that we call statutory safe harbors, statutory minimum, that date back to 1969. So if you looked at the state statute, these safe harbors are in there. So 10% is the big one. And this number has probably changed a little bit because it's a moving target. We've got about 68, 75, depending on, frankly, what day it is, communities that are over 10%. One thing to remember, if you do rentals, if you've got 25% of the units at 80% of the AMI, we count 100% of the units. Or if you do 20% less units occupied by folks earning 50% of the median income, so you've got less units but lower income, we count 100%. Frankly, the towns that have been able to get, particularly suburban towns, 10%, the Westfords, the Angus used to work, the Bedfords, Concord, they go for the big rentals. It's kind of like a Hail Mary. They'll do 200 unit and they're sort of done with it. So in other words, you've got the 40B rent that's, $1,650 a month. You have another apartment that might be $3,000 a month. There's no affirmative marketing. There's no anything. It's just a market rate apartment. We count 100% of the rentals. And we did that to basically bring in, more rental production, because a lot of communities in the state don't allow any rental productions. And that's what we found was a big need. The second one has been a big issue, general land area minimum. And I won't go into the big details on this, but also known as the 1.5%, when low or moderate income housing units on the 40B list exist on sites compromising 1.5% or more total land area zoned for residential, commercial, or industrial use. Again, this goes back to 1969, and it was only used once or twice during the 1980s. We changed the regulations back in February of 2008 to incorporate the general land area minimum. Nobody ever invoked it. Back in 2014, Stoneham said that they had achieved it. So since then, off the top of my head, I wrote down a few of them. I'm still dealing with remote access. We've had Stoneham, Arlington, Weston, Milton, Newton 3 times, Medford, Braintree. I don't know if I said Arlington. Watertown has actually achieved it. So this is become kind of a hot issue. So what we've done is we've released new guidance on how communities can navigate the general land area minimum. And I can send them up to Angus if you want them, but it's very tech savvy. I mean, most of the communities that have done it, you have to really hire engineers. It's so complicated that we actually sort of farm it out to Ty and Bond, an engineering firm, to make the determinations. We just issued a decision on Medford a couple of weeks ago. Well, no, actually just a few days ago. The problem with this is, unlike the 10%, like I can say, West Newbury, you're at 2.5%. You're certified, you have a letter. We don't do any preemptive determination on the general land area minimum. It's up to the community to invoke it, make their argument within the confines of the regulation. The developer challenges it. And unfortunately, a lot of these cases have ended up at the HAC. So just, it's been a tough situation for all involved, I think, as far as sorting this out. The last one I'm not even really going to get into. Annual land area minimum. Community adds more than a third of 1% of housing annually. It's never been used. I think someone's going to use it eventually because it's a safe harbor and it's a pretty powerful one. But those are the three sort of, original safe harbors within the statute. And I think we have one more slide. And this goes back to the safe harbors and the related application thing, and the big project one, which unfortunately I don't think it's going to work. So in other words, the procedure for board decision to revoke all safe harbors. So this is things, that we've added through regulations, or those three kind of statutory safe harbors that I just spoke about. 760 CMR 56038 is the safe harbor procedure. So this goes back to the ZBA. So if you open up the hearing, 15 days at open the hearing, board provides written notice to the applicant with a copy of the DHCD describing which safe harbor has been achieved and supportive documentation. The applicant then has 15 days to challenge it. We have 30 days to issue a ruling. The failure to act by DHCD within 30 days results in the municipal town's favor. The only thing here is under that, the governor's COVID relief, I think it's order 17 or order 19. We do have a little bit more flexibility now because we're working remotely. So we have some extra time. We've been able to do it within 30 days for all of these safe harbors, with the exception of this Medford case. I think we actually, instead of 30 days, I think we ended up using 41. So we haven't been dragging it out indefinitely. So we try to get things done quickly. During the review of the safe harbor, the hearing is tolled. So in other words, that 180-day clock just stops. So you don't have to worry about that. Sometimes communities will go ahead with the hearing if they both want to, both the applicant and developer. Other times it just comes to a halt. Either board or the applicant can file an interlocutory appeal within 20 days of DHCD ruling. And that interlocutory appeal is to the Housing Appeals Committee. And we're not looking at the scope of the entire project. We're just looking at whether or not the safe harbor has been achieved, whether it's, related application, 10% housing production plan, general land area minimum. Now, the last one here is key, and this is why I think that large scale project, even though I think Rick was his name, brought up a very good point. Even though it's considered a safe harbor, it really isn't in a sense, because the safe harbor has to be achieved at the date of comp permit filing. And by achieved, it means those units would have to be on the 40B list, on the SHI list. So when they come in with this application that's above the large scale project cap, you wouldn't be able to deny it based on that because the units don't count. Now, as far as I'm concerned, and I was surprised, frankly, to see those units, those numbers so big, you wouldn't have to, I think the most you could approve is whether it's 93 or 96 units. So that's something that I think you're working with KP Law. I'd have them look into it. But the key is at the end, you've got to achieve it at the filing date. And that's important. That's why the housing production certification thing is really, you get the letter, you know exactly what the dates are. If your community is at 12 or 14% and it's pretty solid, developers aren't even going to go do a 40B because they're going to invest hundreds of thousands of dollars to get to the eligibility to get the application. That's why you don't see 40B, in Cambridge or Boston. Well, Boston's exempt from it. Worcester, the market's different, and they know the town could just say no. So you don't see 40Bs go into communities that are at 15, 16% for a variety of reasons. Next slide, and I think that's it. But I'm happy to answer any questions. I know that I kind of rushed through something, and this 40B is complicated. I just tried to focus on ZBA stuff, but there's other aspects of this financially and how, but this is just kind of a general overview geared toward the ZBA.
Phil, Bill Bacharach, thank you. I have a question. In one of the slides, and it isn't in the PowerPoint that I received, and I'm struggling, and it was where you said that the Zoning Board of Appeals should focus on, and maybe I didn't hear you correctly, health, safety, environmental design, open space, and planning. Is that correct? Correct,
yeah.
Okay. So when I went into the handbook to try to understand what is the definitions of that so that you don't go off the rails when, this comes up,
Yeah.
The definitions, is health, then the Board of Health coming in and giving feedback on that, on the project? Planning would be the planning board. Is that what this is all about? In other words, the different committees coming in to tell you whether these items are good or not, or is there something else? Because it wasn't clear to me from the handbook.
Yeah, no, it's a good question. I mean, usually a lot of times it is the committees, but sometimes you'll have, when it says safety, an issue that comes up a lot is, you know, they'll bring in the fire chief and they want a second mean of egress, or they want to make sure they can turn a fire engine around, or, you know, the spatial differences, you know, things like that. It's a lot of times the various boards will come up and sort of give input, but the important thing to remember is the ZBA is really the decision maker, you know, but I don't think there's a right or wrong, you know, way to go about it. You could, you know, sometimes the town manager will be, or the ZBA through the other boards will sort of say during the public comment period, you know, anything can come up really, but it's not that well defined. And sometimes, and that's where, you know, health can be a big issue for people, you know, it can be almost anything, you know, so it can go off tangent. That's why I think it's important to get, you know, that consultant on board will sort of work through the process, and also a law firm experience with 40B, and KP Law is. So now I think they're doing something in a few days. They probably have a different perspective on certain things because they might be critical of certain parts of the statute or regulation. So they may tell you something differently.
And so then my follow-up is, how do you differentiate the definition between design and planning?
Yeah, I think that's open for interpretation,
Thank you.
frankly.
Yeah.
I mean, planning, I will say this, as far as planning, as far as, you know, you can bring up that you have the housing production plan. There's a few cases that have gone in front of the planning. To me is more what the town wanted for this site previously. There's a couple of cases that were at the HAC. Off the top of my head, one was Middleborough. They wanted this certain site for an industrial park. So it was in the town's master plan. They didn't want housing there. And they were actually went to the HAC and sort of argued on a planning defense that this is not a good site for 40B because we want, and you know, this is an industrial park, it's own commercial. We have somebody ready to move in. And the HAC actually went with the town because they had a strong planning defense. So that's more, you know, whether it's a master plan, housing production plan, open space plan, things like that. That's planning. That's one thing. Design to me is more what the project is. You know, is going to be 4 stories, 5 stories. Is there an atrium? Is there a common love? You know, where the mail? But design to me is more structure. Planning is more, you know, planning, master plan, things like that nature.
Bill, if I could, one point I would add to what Phil said in response to the first part of your question with regard to, you know, comments coming in from other boards and committees, as opposed to, you know, the public, as opposed to consultants the ZBA may engage for peer review. It's important to keep in mind that the Board of Appeals, the reason it's called a comprehensive permit is it encompasses the other permits that a project would normally need to secure, whether that's subdivision approval, that kind of thing. So the Board of Appeals is really acting in the capacity that in another permitting context, the planning board would be acting in. So it is really important for the board to solicit and receive comments from those other entities, even though the planning board per se doesn't have authority in the matter. They obviously have a lot of experience reviewing plans, and so their input is really helpful. Also, the Board of Appeals, as Phil said in his comments, has the ability to engage third-party peer reviews using the 53G account. What that means is the developer puts the money up, the town then engages the third-party reviewers. So the board, you know, would have the support of that technical assistance in addition to the MHP consultant that Phil spoke about.
Yeah, again, it really is a comprehensive permit. So it's sort of, you know, a one-stop shop from a developer's perspective rather than go to all the various boards. And I think that's part of the reason why it can be tough for communities to deal with, because the ZBA is sort of, you know, every aspect of this project that generally would be handled by other boards or committees or whomever. It's really their responsibility.
Paul, I would suggest if there's other questions from board members or staff, we could go with those. If not, we do have some residents on the line. We could open it to broader questions, but I'll defer to you as chairman.
Well, I have a question. Is the applicant supposed to be a nonprofit or something like that? Did I read that in these regs here?
Yeah, they can be a nonprofit or a limited dividend organization or a public agency, but most of them, and I suspect this one is, they'll form a LLC or limited dividend organization just for this project specific, but they don't have to be a nonprofit.
Okay.
There are 40B developers, that are kind of human service agencies, or like, you'll see the regional nonprofits like SMOC or various groups on the North Shore, like Harbor Lights. They do a lot of work in Beverly. They do 40B too, and they're nonprofits. But in order to do a 40B, they have to be, and it's a fairly straight process. They just form one with the Secretary of State's office, and that's something that the subsidizing agency will make sure that they've done.
Okay.
Yeah. And a lot of times they will form these corporations just as a one-off. So whatever the project is, it'll say, Mystic Valley or Limited LLC of Medford or whatever. They just create an organization.
Okay.
That's a good question, though.
Angus, what's next?
Actually, I have a couple questions on timeline, perhaps, that's
Right.
right. So with the June 16th period, which is when our public comment closes, there then is a 30-day mass housing review period?
There's not really a set time frame. That's a good question on how long mass housing will take to issue if they do issue an eligibility letter. I think it's confusing. I think there's generally a 30-day comment period, which has been extended, and that's where I think that 30 days came from. But once that project is closed, it's more of an administrative action on mass housing's behalf. So in other words, there's no regulation or guidelines or anything that I'm aware of that says, once a couple of the comments are in, mass housing partnership, PhD has to make a decision within X amount of days. Sometimes they drag on for, it could be months. They'll make a decision. They have to. It's administrative action, but there's no set time frame on it. So I wouldn't hazard a guess. That would be something I talked to mass housing about.
Right.
They might be able to give you a frame of mind.
After June 16th, the town comments go in through the Board of Selectmen.
Right.
It goes to a mass housing review period that could be a week, or it could be 6 months, or it could be whatever.
Depends what's on their plate. Yeah, you're not wrong. Yeah, I mean, it's not going to be a week, but it could be a while. I know they're backed up and staff and working remotely too. So I wouldn't want to speak for them because I don't really know what exactly is on their plate. But
so then once
no
they
set
get
frame, I can say.
once a PEL, so then the next step would be the issuance of a PEL, project
Right.
eligibility letter. And then the developer goes through and finalizes their review set or finalizes their submission?
Well, once they have the PEL, depends on developer. Now, I've seen developers that they get a project eligibility letter on a Tuesday, and they roll up the town hall on a Wednesday at 8:45. Others, because they might be thinking there's 3 or 4 projects in line here, they're getting close to 10%. I think also what's happening, and it didn't go into this, these big numbers as far as your production goals, 10%, we don't update the denominator annually. So those numbers for your town are based on 2010. Once we hit 2020, everything's going to change. So communities that are 10, 11%, if they've added a couple hundred units, they could fall below. A lot of the more sophisticated developers, as soon as they get the eligibility letter, they line up, the next day or two. Now, other ones that aren't as sophisticated, don't have the resource, it could take them quite a while to get everything together because the application itself is, you'll see it when it rolls in. It's big,
Sorry, the application, when did the applicant, I thought the application's already been filed.
Well, what happened in this situation is they've applied for the project eligibility letter. So it's not a full So that's one step. So the real step is they have to get this eligibility letter. Once they get the eligibility letter, then they can get one of those files, everything that's included that they have to submit to the ZBA. That's when they can come in. And it's a good question. Another one is, but it's hard to tell. If they get the eligibility letter, in theory, they could file the same day. And I've actually seen that happen too. Other times it could be a couple of months, you know?
So, I mean, I'm trying to get the board to to realize the timeline here. And it could, you know, if there's a very quick turnaround, not that you expect it, a quick turnaround with the mass housing review period, and then a quick turnaround from the developer to file the comprehensive permit, it could be a matter of weeks or a couple months.
It's true. Yeah. And it's really hard to tell. And, you know, you could ask mass housing. My guess is usually when people, because I get that question a lot, and it's sort of like, you know, I refer them to the subsidizing agency, and sometimes it takes them quite a while to issue it, just a staffing issue or everything else. And then there's other things that can happen, and, you know, but there's nothing regulatory or statute that says they have to act within X amount of days. So just stay tuned, and, you know, they'll usually give the town a heads up when they're about to issue it. You know?
And you might have said this, but does a project eligibility letter have a time expiration date?
Yeah, that's a good question. They're good for 2 years, but frankly, they often extend them, and the extension is at the discretion of the subsidizing agency. But it's 2 years. Things are hot right now. I don't know what's going to go with COVID long term, but the market was on fire, so no one really needed that extension. Now, when things blew up in 2008, 2009, we had these 40Bs just become they disappeared. Everything fell apart. And developers were asking for extensions of years sometimes, and would receive them. But short answer is 2 years, but it can be extended.
Thank you.
Yeah.
So when an application actually comes into the ZBA, is it generally better fleshed out than the project eligibility letter application? But you know, for instance, the material that we've seen so far does not seem to really take into account the land that's really there. It doesn't address topography and other features of the land seemingly at all, or almost not at all. I mean, there's a fair amount of engineering time required in order to get it to a point where it's a real project, it seems to me at this point. But can they go ahead and submit the paucity of information that we've seen so far, and force the town to essentially, you know, flesh out the design for them? I'm puzzled by that.
It's a good question, and I don't want to venture too far into the specific project, even though I know that that's what people probably frankly want to discuss. They generally are a bit more sophisticated, but when they come in with the actual application, they're still preliminary plans. Most of the time it is a bit, hopefully they've made some adjustments, because what happens is in the eligibility letter, they say, you know, the town raised all these concerns, and if developer is working cooperatively, they've made some changes. Usually it's a bit more sophisticated than probably what was submitted for the eligibility letter. But again, I haven't seen either what they submitted, and I probably wouldn't want to comment on it. And once they get in there, there's a lot, you know, between peer review, a lot of the times things change. I mean, you might see massive, you know, the buildings change, the number of buildings, units, where they're open space. That's where it becomes a negotiation. But it's usually a bit more sophisticated when it gets to a complete application. Sometimes communities will argue that it's not a complete application, and that can go down a whole different route. So that becomes a kind of a legal problem. But it's usually a bit more sophisticated than what's initially submitted for an eligibility letter.
Thank you.
Bill, in regards to the complete application, if we have guidelines set up that list out what's required for a complete submittal, and they don't, you know, comply with that, where do we stand at that point? Is the 180 days still running, even though
Yeah, well, that's a good question, because I know communities adopt their own guidelines, and frankly, there's something in the regulations that says that those guidelines or, you know, local practices should be submitted to DHCD for review. Nobody frankly does that, and we don't have any authority over we don't approve them. And frankly, most of the times we don't see them. So it's, if you would argue that, you know, that and I could get more in depth in this, or if you want to look at the regulations and the guidelines say exactly what should be in the application. Some of that is open to interpretation. You may not like their engineering, preliminary engineering, or their spacing or design, but as long as something's in there, that's usually enough to say it's a complete application. Now, sometimes communities will adopt their local guidelines that are in clear violation of the regulations and guidelines, and that gets messy. So that's something that it comes up once in a while, and community will claim it's not a complete application. Generally, at that stage, it can get messy because either DHC, the subsidizing agency, the various attorneys will just start fighting, you know, to whether or not it's a complete application. And then sometimes we would step in and sort of say, yes, this was complete, or this is missing. But most of the 40B developers are pretty sophisticated. By they get to this stage, they've got a lot of money invested, so they're going to try to submit a complete application.
Okay.
You know, like if he didn't have, or he or she, if they didn't have site control, you know, that's a big part of it. Or they missed 3 of the 7 requirements. Yeah, you know, but that generally doesn't happen. But if you start getting into, we want it to happen this way, and there's not a regulatory framework to support a lot of the towns on that end of it.
Okay. Thank
And
you.
a lot of towns will just adopt these things quickly too, you know, and it's like, because sometimes I'll see things and I'm like, oh, mate, that's not, but they're not submitting it to us and we never see them, you know? Yeah.
Any other questions for Phil?
Can you hear me?
Yes, Rose, we can hear you.
Oh, thank you. Thank you, Mr. DiMartino. I have a question that's a little bit unrelated. Would the state ever consider counting a municipality's 40B affordable housing units on a regional level? Given that a small town like West Newbury has difficulty in meeting with 10%, however, we are neighbors to Haverhill and Newburyport, which have more of an opportunity to provide affordable housing to citizens. Now, I know that the planning board worked with the Merrimack region in putting together the housing plan, and there's a regional housing plan as well. Would the state ever consider allowing small communities to bond with larger communities in fulfilling a 10% goal?
Yeah, it's a good question. I remember back in like 2002, 2003, under the Romney administration, there was some talk of that, you know, sort of sharing the, you know, this community would be more appropriate, whatever. Short answer is under the regulations and statute, no. It's really 351 cities and towns, 10%, that's it. There's really no consideration for smaller communities, and I think that's part of the criticism that has some valid points to it.
Too nice.
Under the
Okay.
existing, not to cut you off, but under the existing statutes and regulations, it wouldn't be allowed. Now, we've had some communities that have done 40Bs that, you know, say they've shared systems, water systems, electrical, but they can count one project, but the communities have agreed to count 20 units in this town and town B, but they are physically sited within that specific town. So that it's a good question. It comes up a lot, but I mean, it's far, unless they change the regulations and statute, that they'd have to change the regulations and probably the statute to allow that. And I think the housing advocates would push back at it. But short answer is no, but it comes up a lot. It's something that's been thought of, and I've heard about it, but it wouldn't be allowed now, you know.
Thank you.
Thank you.
Thank you.
All right, are we ready to thank Phil for his time?
Thank you, Phil.
Thank you.
Thank you, Phil.
Thank you.
Any,
Yeah.
yeah, any
Hey, Phil,
questions?
that was
Thank
great.
you. Thank you. Any questions, probably through Angus, or you've got my email, contact me directly. And sorry if I ran through it because, 40B, I realize it's an overwhelming process, and I could do 40 slides and confuse people really even more than I probably did, but it's not an easy process. But I'm glad that you're getting, you've got a town manager that's got a great planning background and good people there, and you'll get a good consultant, and hopefully end up with a project, and we'll see which way this goes. But whatever issues you have and concerns, now's the time to bring them up to mass housing, because I think the key is really, once an eligibility letter is issued, it's out of the barn, and then they're hard to stop. And I would try to get the best project you can at the ZBA level, would be my unofficial official advice if it gets to that stage.
Thanks again for being available.
Thank you.
Thank you, Phil, very much.
Stay safe. Good luck with everything, and let me know if I can help, okay?
Great.
Thank
Will
you.
do.
Thank you.
Bye.
Bye.
So, Mr. Chairman, the next,
I'd like to make a motion. Could we make a motion?
Yes, you may.
Is that the next step, Angus?
yes,
I'd like to make a motion for the West Newbury Comprehensive Permit 40B rules. And I was going to add in also the regulations for filing appeals be reviewed by the staff, and that the staff recommend revisions to such.
Well, I second that.
Motion.
Okay. Any discussion on the motion? All in favor of the motion, say aye.
Aye.
Aye. That sounds like a majority to me.
if you wouldn't mind just doing a roll call vote, just so we've got it for the record.
Okay, Paul Kelly says aye. Pat Hagan says,
Aye.
Judy Gregg,
Aye.
Mr. Lucy. And your vote, Mr. Lucy?
Unmute, Dennis.
Thank you.
Oh.
I'm the alternate, but if I'm voting today, my vote is yes.
All right.
Whoop.
Aye as well. Bill Backrack, aye. Hi,
What?
Bill Backrack, aye.
Oh, yeah.
Hi, Paul.
Okay, so that's a majority and the motion passes.
And we forgot to state at the beginning of the meeting where Rick Davies is not here, that Dennis Lucy will be filling in
Right.
and have voting status. So put that on the record.
Okay, thank you. Motion to adjourn?
If we could, before we get to there, I would ask, would the board prefer to see draft regulations and then refer them to public hearing? Or would you prefer for your next meeting, presuming that's a couple of weeks out at least, that would actually be a posted public hearing to consider proposed revisions to regulations?
Mr. Higgins, do you have, go ahead.
Hang on, I think Dennis, you have to unmute.
Yeah.
I did that again. Can you repeat the two options? Sorry.
So we'll be working with KP Law to prepare either proposed revisions or potentially a delete and replace an entirely new set of regulations. So my question is, would the board like to review the draft that we prepare and then refer it to public hearing, which would mean 2 more meetings? Or would you prefer that we go ahead and advertise a public hearing? That way you'd be reviewing them for the first time in public hearing. So it's really your preference.
What would you suggest, Angus?
I think that if there's one or more board members that's less than a quorum who wants to be kind of engaged on a day-to-day basis with the draft, that's going to give, especially where Sam and I are still pretty new with the town. John Whitten is very, he's just outside council. He's brand new. So we want to bring something forward that meets your expectations. the best way for us to do that is if there's some representation from the board in the working group. If we have that, then I think if we get to a draft that we feel the board is going to receive favorably, then we could go ahead and schedule a hearing. If it's something that staff is preparing and bringing to the board, then I would suggest you have a meeting to see what you think of what we've done and then refer it to hearing.
Angus, this is Judy. I'm thinking that the board should have a look at what you've prepared and draft and have a chance to discuss it. That is, if in fact no one of us is participating in what you are doing. But I think it would be better to have a look-see first before it goes to hearing. That's my.
That would definitely be the normal practice, and I would agree that makes sense. The only reason to consider otherwise is if either in the interest of time or if the board simply doesn't, wants to minimize the number of meetings, you could go straight to hearing. But what you're describing, Judy, is definitely recommended, because once the hearing notice is in the paper and the public shows up, it wouldn't represent the town very well if you get into hearing and then the board is saying, hey, we don't really like what the staff did here.
Okay.
Can we then have a motion to proceed in that fashion, that you provided the board with your draft and we review and comment before? Do we need to make a motion on that?
I don't think so. I think if everybody is in agreement, unless somebody speaks up in the alternative, I think that's how we'd proceed. We'll work on a draft and we'll circulate drafts or questions as we go forward. We could either set a meeting date now, or we could just see how it goes. The goal that I've set would be to get regulations approved before June 16th. That is not a magic date. And in fact, what really matters is that any regulations be approved prior to a submittal of a comprehensive permit, which by my estimation would be at least 30 to 60 days after that June 16th mass housing deadline. At least. I think it's going to take mass housing that long to turn around their letter. With that said, I don't want to take any chances, and I think it would present well if, when the town comments go to mass housing on June 16th, already approved these revised regulations. I think that's the best thing if we can do it. But that's only about 4 weeks away.
Mm-hmm.
How long would you estimate it would take staff and everybody working on it to have something for us to look at? 2 to 3 weeks, or are we?
I think we could have something in 2 weeks for sure. It's not obviously we're not reinventing the wheel. We've got a few samples to draw from. If the board members have any input on what you've been provided, on different elements that you like or don't like, or especially if there's things in the existing regs that are very important to you that we retain, that would be really good feedback. If there is feedback, if we get that in the next, say by Monday, then we can, I think we could turn something around within 2 weeks, or in 2 weeks, I would say.
And we're looking at a few other boards from other towns, similar regulations. And then initially we had said to look at like Westbridge as well. Those weren't included in different submittals that we're looking at. Should we still look at Westbridge as well with those compared to those other towns? Is that something?
I like what, I mean, I worked there for a few years, so obviously I'm familiar with it, but that's a town that really takes things really seriously.
Yeah.
They, I think, do a really nice job. And I know, Sam, you took a look at those and you were favorably impressed. The only reason I didn't send them with this recent circulation is because I had already sent them around and the file is like 10 or 12 megs. So I figured, didn't want to bog down your inbox.
Okay.
So Angus, can you just review the process? So you said you'll send the draft around, and then we're able to go ahead and provide you feedback, and that won't conflict in open meeting law or anything like that?
So if we had a draft and if staff had a draft that we circulated to the board, Judy had suggested each board member could provide feedback. That does get a little dicey. If each board member sends an email directly to me and or to Sam, that does not conflict with the open meeting law because you're not deliberating amongst yourselves.
Right.
So that is totally in bounds to do that.
So that's fine. That was my point. Just make sure
Yeah.
that.
Yep.
Okay.
We can't communicate between each other, but we can go directly to it in a straight line to Angus and that way.
Yeah.
Right.
Yeah, okay. And when will the draft be sent out? Or did you already send it? I missed it.
No, I didn't. I sent just the sample. So,
All right, I got the samples. I got it. Thank you.
yeah. So we're going to aim for 2 weeks.
All right, thank you.
So should we pre-schedule meetings for like 2 or 3 weeks and then have another week and have a second meeting after that scheduled? So we have meetings all set up, ready to go, or?
I think if you're going to have a public hearing to actually vote regulations prior to the 16th, I would think that public hearing would need to be sometime the week of June 8th. So I think you would need to meet, at least a week prior to that.
Yep.
To refer something to hearing.
Okay.
So I think we'd be looking at a meeting each the week of the 1st and the week of the 8th. Or potentially it could be Monday the 15th, but I think I've got a selectman meeting that night anyway.
Well, this takes 2 notifications in the newspaper. The last one is a week before the meeting, so that's 3 weeks ahead of the meeting. So that's like tomorrow.
Mm.
And I don't know, Joan gets them into daily news, takes a day or so, but
Right.
Actually, I do not have a meeting on the 15th, so that actually that would give us the most amount of time if the board had the public hearing on June 15th and then met some amount of time prior to that to refer the regs to hearing.
okay.
So just the public one would have to be
2 weeks.
sent into the newspaper, correct?
Correct.
Okay.
And
Why don't we leave it this way? If each of the board members can send me and Sam an email with any dates or any conflicts that you have from June 1st through June 15th. And then if you can do that within the next day or so, and then we can pin down 2 dates for 2 meetings, and we can work with Joan on the lead time that we'd need for a newspaper ad. And we can get back to you ideally in the next 2 days to lock in those dates.
Sounds good.
Yeah.
Great. I think that concludes what I had hoped to get done.
now is the time for a motion to adjourn from somebody.
Do you want to, while we're here, Jenny, on the dates between June 2nd and the 4th, do you guys want to set up a time and date for a meeting then? While we're all here? Trying to pin you guys down. And
For what purpose would that meeting? Pat,
so we could review the regs and then refer them to a hearing for the next week.
do we have, does that have to be an open meeting?
Yes.
Okay. So we don't have time to advertise that.
The meeting is just a 48-hour posting of the agenda. It's the
Right.
hearing that needs the advance time with the newspaper.
So I would post this the same way as I did the other one, just on the town website and in-house.
Yes,
How's the week going?
and Sam and Joan, the three of us can work together on the public hearing notice, but I've definitely seen many times where a public hearing notice is sent to the newspaper before the proposed regulation is actually available. And as long as the hearing notice states the date that the regulation will be available for public review, and as long as that date meets the advance notice requirement, it's fine. So Paul, to your point of, 2 consecutive weeks, with the second one being a week prior, it would be fine if the first public hearing notice appeared in the paper before we actually have the regulation in the form that we want it. It's not ideal, but it's totally legal and it's fine. And I've seen it happen many times when time is an issue.
All right, I'll leave that fine tuning to you.
How about Tuesday, June 2nd? That would be 2 weeks from today.
Okay,
Is there anyone that would not work for?
fine with me.
Is this time of day good? Do you prefer in the evening? I think I can safely speak for staff. We love this time if it works for you guys.
That's fine by me.
Yeah, fine by me as well.
It's fine, no problem.
I'm good.
All right. Paul left, so he might be checking his calendar. Here he is.
Yep, that's fine.
Okay, good. So we'll post an agenda for Tuesday, June 2nd at 4 p.m. We will circulate draft regulations. We'll aim for no later than the prior Friday so that you'll have the full weekend to take a look at them. On the 2nd, you can give us feedback on the draft and then refer that out to hearing, which would presumably take place either late the week of June 8th or possibly early the week of June 15th.
Okay.
Do we want to try and set the hearing date on the week of June 8th, like on the 10th or the 11th, Wednesday or Thursday? If people can check the schedules and fix that in. That way
All
they're
fine. All okay with me.
The 11th would be better just in terms of having that extra day for the newspaper ad.
Sure.
Yeah,
Yeah. Okay.
so the 11th will be the public hearing?
It sounds like it.
Okay,
Can everybody check their schedule and see if we're all available on Thursday the 11th?
Works for me.
and pin down a time.
Yep.
I'm good.
I'm good.
Me too.
I might have to check. I might have to make it. I can get back to you very quickly. 4 is fine, but I can get back to you tomorrow. I might have to push it to 6, depending on the work schedule issue, if I can't move it.
All right. So right now, tentatively, both meetings are going to be at 4 p.m. on the 2nd and the 11th.
Correct.
Okay. Just keep me in the loop.
Thank you, Joan.
I'm so good at these Zoom ones. I'm kidding.
Yeah, Angus was very impressed with our coordinated effort to get this together.
Hey, it all came off without a hitch, so that's all.
It did. It did. It's a big learning curve, so we'll get it.
Thank you, Joan.
You're very welcome. Thank you for all your patience and understanding.
Angus, I think, were you sending an email out? No, there you go. You can hear me. Were you guys sending an email out about dates for a site walk, or is that later?
Yeah, I will. I've asked the developer a couple of times to suggest some dates and times. I think it's going to be better if I go ahead and poll the board and then suggest some dates and times. He did say that he felt it was a little premature for the board to get on the site because there's not actually anything before you at this time.
Yeah.
But, you know, my feeling is if there's, you know, public officials who want to walk the site, my hope is he would accommodate that.
It would be beneficial if we do actually schedule a site at any point moving forward, that we have like a full-size set of plans, like as opposed to these PDFs and things. So just the site plans, just so when we walk it, we can try and orientate ourselves out there. I don't know if you had those on Friday or not, but
We did not.
yeah, you don't know where you are unless you can kind of should have them
Yeah,
show you where you are.
We just had 11 by 17,
Yeah, that's
which
not helpful.
the video from Friday's site walk should be posted in the next couple of days. I've been working with Adam, who's also recording this meeting tonight. So he's been putting together the various video clips into a cohesive program. So that'll appear on local cable soon.
Yeah, and for anyone who hasn't had a chance to watch John Witten's presentation from the other night, it was really excellent. You know, and no, Phil did a fine job, but I think John, I don't know, he really hit it out of the park.
Well, he presented it with a different, you know, the commercial aspects and the legal lens.
Right. Yeah, just different point of view, and I think it's more the point of view that we look at it as.
Yes.
How do you access that site walk on the YouTube?
It'll be on YouTube once it's available. So once again, it's being produced right now. The Robinson was uploaded yesterday morning. So it's, you know, take a little time to put that all together. And I did a markup of a map to kind of index where each video was shot. So it's not just footage of trees, there's some physical orientation to produce that all into a video that kind of is actually watchable. You know, it's going to take a little time. I don't think it'll take more than a couple of days. I expect that'll be up by the end of this week. Once it is up, I'll post that to the town website and send out a notice.
Okay.
Can I have musical background?
Probably, yes.
Good.
Did I hear a motion to adjourn?
No, I didn't hear it.
Motion to adjourn. Took the words out of my mouth, Angus.
I second it.
All in favor, say aye, or maybe I,
Aye.
that's unanimous. Sure.
Thanks very much, everyone.
Yep, thank you, Angus.
you.
Thank you,
Thank you.
Sam.
Have a good one.
Okay. Thanks, bye.
Bye.